have two bill hearings today. We're going to get started with Senate Bill 204. We'll open the hearing on that one and have Natalie give us an overview.
Mr. Chairman, Senate Bill 204 prohibits a court from requiring psychiatric or psychological examinations of an alleged victim of any crime. Section 1 enacts new law to provide that in a prosecution for any crime, a court shall not require or order a victim of the crime to submit to or undergo either a psychiatric or a psychological examination. That new section, if enacted, would be part of the Kansas Criminal Code. And I would note that this bill is something that you guys heard last year, Senate Bill 355. You guys did make some changes to that, as I'm sure you'll recall. And if you have any specific questions about that, I can take them.
Thank you, Natalie. Any questions for Natalie? Not seeing any, so we will begin with our proponents. Virtually, it looks like we have Lindsey Ford.
Hello.
Hello. Hi. My name is Lindsey Ford, and it's a pleasure to speak with you all today. I am the staff attorney at the Kansas Coalition Against Sexual and Domestic Violence. Some of you may remember I testified on this exact issue last year as well. It's a pretty straightforward bill, but I think the points behind it are very important. So an individual's mental health should really never be a factor in whether or not they are allowed to seek justice for a crime that's been committed against them. Whether it be a violent crime or a sexual assault, nobody should be hindered from accessing the court systems or being treated with respect by the courts because they have some sort of psychological symptoms. This is especially important when we think about how individuals with psychological disabilities are extremely more likely to become victims of crimes in the first place. And I included some statistics about that in my written testimony that I'm not going to repeat for you right now. But it's also important to note that being the victim of a crime can be a traumatic experience. It can cause post-traumatic stress disorder, depending on the severity of the crime and the victim's experience. And that could be reflected in a psychological evaluation. And those symptoms could be used to undermine the prosecution of a perpetrator, even though they were caused by the actual perpetration of the crime in the first place. And lastly, I really just want to take time to draw attention to the fact that psychological evaluations are extremely invasive. They require time, they require energy. And when you have a victim whose personal autonomy has already been violated by whatever crime was perpetrated against them, asking them to undergo even further violation of their sense of self is really just not something that I hope the state of Kansas wants to be involved in. And with that, I would be happy to stand for any questions.
Great, thank you. Committee, any questions? I am not seeing any. Thank you very much. We will move on to Todd Thompson. I think Todd's online as well. Actually, yeah. See Todd's name. Are you out there, Todd? We may come back to Todd in just a second. Well, actually, let's see. Julianne Walker. Julianne, are you just written? I think are you online? Let's see. You're online. Are you just written, or did you want to, you're just here to watch?
There we go. Yeah, my testimony was just written, but I'm happy to stand for questions if there's anything within the written testimony that I can clarify.
Okay, committee, any questions?
Thank you.
Okay, none there. I see Todd's online with us now. Hey, Todd, you're up.
Thank you, Chairman. I'm sorry. I could not hear anything that was said before, so I assume it went over smoothly.
Said lots of good things about you.
Oh, well, it's on the record then. This is a very important matter. I'm Todd Thompson, the County Attorney of Leavenworth. I'm also the chair of the Legislative Committee for the Kansas County and District Attorneys Association and the past president. This bill, and again, if I'm repeating some of the information you've already heard, it was passed almost all the way through and just was stopped due to COVID last year. This is a very important bill, not only to our organization, to myself. We actually have 3 ongoing cases now, and one that a young child is actually being submitted for an examination. Again, I said that we had done this previously, and what I want to note is, I don't know how many of you have ever been a victim of a crime, but imagine that you report your crime and then you're told immediately that you need to have a psychological examination because they want to know if what you're doing is serving some type of fantasy. That's what's being asked of our victims of sexual trauma. You know, at this point, I mean, I can't imagine many crimes that are much worse than a sexual trauma or sexual assault. And usually they're done from someone that they trust, they love, a close friend or relative. And then they ask them, you know, they have to go through telling law enforcement, strangers, forensic investigators, prosecutors, even doing it in front of the court. And then they're told, hey, by the way, you have to have this examination. This law, this law came about back a long time ago. It is archaic, it's misogynistic, it is just unfair for them to have to go through this type of examination. As I quoted Kim Parker, who was our prosecutor coordinator for the Kansas County District Attorneys Association last year, who had tried multiple cases, including the BTK case, one of the things she said is that the veracity of a sexual assault victim should be subject to the same tests all other victims are: solid investigation, a prosecutor's careful review of the facts, thorough cross-examination by defense attorneys, and a determination by the court or a jury for the credibility of the evidence in the testimony. It should not be done in the way that it's being done now, and for that we're asking for this bill to be passed, and I stand for any questions. Thank you.
Any questions, committee? I am not seeing any. Thank you, Todd. Is there anyone else online or in person as a proponent? Do we have any opponents?
Mr. Chairman, I apologize. I could not get my hand up in time.
No worries. Representative Carmichael.
Thank you. Mr. Thompson, how many cases per year are there where psychological evidence based upon a defendant's examination, how often is it requested? How often do courts grant it? How often is the testimony actually presented?
I can't give you an exactity. I can tell you that we've seen, like I said, just in the last 6 months, I would say we've had 3, and 1's granted and 2 are awaiting motion. That's just in Leavenworth.
Okay, but I mean, my experience has been that these types of motions are often made, but seldom if ever granted, and only in the most extenuating of circumstances. But my experience is not the same as yours. But talking to you, it sounds like it's happened once that you can identify. Now, I assume it's more often than that.
Well, I'm talking in just in my county, and in just one in the last 6 months that I can tell you. It probably does happen. What I would ask you, and I know you're asking the questions and not me, but why is this fair only for sexual assault victims? And sexual assault victims, again, statistically are usually female. And for a lot of our cases, young children, young female children. Why are they being forced to have this analysis to them when you don't do this for any other case, any other crime? It's just not fair. Not to mention that the whole reason that this law or this policy even exists is based on false psychological idea that people of who are a victim of sexual assault are creating this story for their own sexual fantasy. That shouldn't even be an opportunity. If that happens to be the case, then that should be vetted, cross-examined, and looked through in the normal course. It shouldn't be allowed through this type of procedure that we don't do for anybody else.
The answer to your question is because we are making laws of statewide application that apply in every case, and that judges, in my experience, are extremely reluctant to permit such an examination. And I need to know how often this happens and what the extenuating circumstances are that would cause a judge to enter such an order. I'm critically concerned about the Sixth Amendment right to confrontation, and I recognize that that right is limited. But a defendant who is being accused of a crime should have the opportunity to rebut evidence against him or her. And so I'm not saying that this is a good idea for us to keep doing this, but this is probably the fourth year that I've heard this type of legislation in one fashion or another. And I would think that by now, the prosecutors could tell us how frequently this happens, because I suspect it's barely a handful of times. And my guess is there may be genuine reasons, but without that information from the conferees testifying in favor of the legislation, I have no data set on which to make a determination. So that's the answer to your question, sir. Thank you, Mr. Chair.
Okay, committee, let's see. I didn't see any opponents. We do have one written neutral conferee on behalf of the Kansas Association of Criminal Defense Lawyers. Is there anyone else as an opponent or as a neutral? Not seeing any. We will close this hearing and now open the hearing on House Bill 2122 and head back over to Natalie for an update.
Thank you, Mr. Chairman. House Bill 2122 would enact the Supported Decision-Making Agreement Act. This would allow adults who may or may not be under a guardianship or conservatorship to make decisions regarding such person's life with the assistance from one or more other adults. Those are referred to as supporters throughout the act. The duties and obligations of the principal, which is the adult receiving that decision-making support, and the supporter are agreed to in a supported decision-making agreement. Those agreements have to name each supporter providing the principal with assistance and the scope of the assistance that each supporter would be providing. One agreement would be able to include multiple supporters, and they could name alternative supporters who may assume the duties when a supporter that's named in the agreement is unable to fulfill those obligations. Each agreement would also be required to contain a notice to third parties summarizing the rights and obligations of each supporter named in the agreement. Each supporter would also have to make a declaration acknowledging the supporter's relationship with the principal and their willingness to provide assistance. Each declaration would be incorporated into that supported decision-making agreement. To be valid, each agreement would have to be signed by the principal, each supporter, and it would either have to take place in the presence of two independent witnesses, or the signatures would have to be notarized. The agreement also would have to be. An agreement may become effective on a certain date and may be effective for a certain period of time. If no dates are provided in the agreement, then it is effective upon execution and terminates upon a subsequent action by the parties to revoke that agreement. An agreement may be terminated either in whole or in part. And if the principal terminates all or a portion of the agreement, then that termination has to be in writing and signed by the terminating party. If there is a partial termination, then the non-terminated provisions of that agreement would remain in effect. Under the agreement, a supporter would be able to provide decision-making assistance regarding the affairs of the principal. Those affairs are described in the Section 2, subsection B. They include a variety of things listed there in my brief and in the bill. Under Section 7, a supporter can assist the principal in understanding and communicating decisions, obtain information relevant to a decision, and assist the principal in understanding that information, ascertain and assist in communicating the desires of the principal, and accompany the principal and participate in discussions relevant to any decision. It also lists 5 items there that a supporter would not be able to do, which would include exert undue influence on the principal, make decisions for or on behalf of the principal, sign for the principal, or provide an electronic signature to a third party, obtain information not related to a decision, or use information acquired for any other purpose other than to assist the principal. A supporter's assistance would not be able to encroach on the authority of a guardian or conservator if there is one appointed to the principal. All information would have to be kept confidential. A supporter acting in good faith would not be liable to either the principal or a third party for damages arising from a decision made. Section 8 provides that a third party would have to recognize the decision of a principal made under a supported decision agreement as a legally binding decision. But a third party would not be liable for failing to recognize that decision if the third party had actual knowledge that the agreement was invalid or has been terminated, or the decision is related to health care and it's contrary to the good faith medical judgment of the third party. Section 9 provides that the presence of a supported decision-making agreement would not be able to be used as evidence that the principal lacks capacity to make legally binding decisions. And the principal may legally make those binding decisions without receiving assistance under the agreement. Section 10 amends KSA 2154-17. That's the crime of mistreatment of a dependent adult or an elder person. This section is amended to include violation of this act as one of the means of taking the personal property or financial resources of a dependent adult or elder person. And I can take any questions.
Questions, committee? Representative Humphreys?
It's the question. We've seen this before.
We have not, but maybe Natalie knows who has heard it before.
Okay, what
Different
did
committee.
we pass that was very similar to this? Where we had lots of proponents come and it was very similar. Natalie, can you enlighten us on that? Maybe it was 2 years ago?
Mr. Chairman,
Fed and State has heard this before.
It's Fed and State.
Fed and State. Maybe that was what I'm remembering. But yeah. Do you know
Mr. Chair?
Natalie? Was it in Fed and State? Okay.
So
Thank you.
last biennium, the Committee on Federal and State Affairs heard this issue. It was House Bill 2034. If you want to go back and look at that, on the House side, it did come out of Federal and State Affairs. It did cross the floor, and then it had a hearing on the Senate side. That did, though, become the vehicle for the restitution bill that you guys did last year. So you might recall that.
And is it basically the same bill, or are there any changes, Natalie?
It is basically the same. There are a few minor changes. I would have to go through and pinpoint exactly what those are. I didn't mark them. I should have done that, but there are only very minor changes.
That's fine. I don't know that there's many of us on this committee that actually were in Fed and State that time anyway. So, okay, thank you.
Any other questions for Natalie? Not seeing any, we will move on to proponents and committee. Let's have everyone testify and then save our questions to the end because we might get some answers along the way and not have to ask those questions. So with proponents, we will begin with Steve Gaber. I'm sure I butchered that, but I did ask Mike Burgess how to say it, so blame Mike. Oh, maybe that's what he told me. Shoot, I'm not even good at writing things down. Well, thanks for being here, Steve.
Okay, well, thank you for allowing me to do some testimony on this, and excellent memory on remembering this bill from a couple of years ago, because it did go through Fed and State. I'm Stephen Gaber. I'm the Executive Director of the Kansas Council on Developmental Disabilities. The council is made up of self-advocates, family members, and state agencies, and our partners identified in the Federal Disability or Developmental Disability Act. The council's role is to advise policy members and makers on the issues impacting people with intellectual and developmental disabilities and their families. The council is here in support of House Bill 2122. This gives families and individuals a lot more tools to allow people to make independent decisions and get the support that they need to be successful in life. Currently, there are over 17 states that are working on some form of similar supported decision-making policy. This state law and guardianship is very consistent with the position statement from the National Guardianship Association, which I did include that in one of the handouts. And just to let you know, they've endorsed supported decision-making and believe it's really important for modern-day respect of individuals' rights, dictate that we must allow each individual to make and participate to the maximum extent possible in personal decisions, and that supported decision-making should be considered for persons before guardianship, and then supported decision-making process should also be incorporated in guardianship as well. We held a lot of grassroots meetings across the state, visited with a lot of families, and there's an awful lot of families out there that really do want to do supported decision-making as an option.
I got it, thank you.
And that's one of them on the line now, I think. I did want to tell people too that Dr. Carrie Sjogren from KU is one of the professors there, and she recently published a book on supported decision-making. So KU is actually one of the leaders in the nation on the research and the activities around that. As we look at research on people that have intellectual and developmental disabilities, the only research that we really have on guardianship comes from our national core indicators. And the state of Kansas has about 65% of the people have guardianship, and the national average is about 35%. So we have a lot more guardianships in Kansas than most of the other states. There are actually states that have less than 5%. And we believe part of that reason is because whenever students are coming up on the age of 18, a lot of our schools are encouraging people to get guardianship. And what we want to do is we want to have supported decision-making be an option that schools can offer families as well, so that they can still be engaged in their child's IEPs and those kinds of things. And we have been working with the Department of Education, and I believe they are very much in support of doing that. We've also been working with Washburn Law School to develop some training CEUs and those kinds of things after hopefully we get this passed, and then we can start doing training and really give the families these options that we've been trying to develop. And I think you'll hear from some family members, and a lot of the written testimonies from family members as well. And so with that, I will reference the Supported Decision-Making Agreement Act, which is another document that we've included in your written material. And that really just kind of outlines why we want to see this particular bill passed and what we plan on doing with it. And as far as the changes, they were extremely minor. We actually had a self-advocate this last summer challenge us on a couple of things that we had in the law, and they said this really isn't right. If you're really giving me the right to make a decision, then why are you limiting my decision? And we said, you're right. And so we went ahead and we did make that change. And so anyway, again, just a minor change, and it was really driven by individuals with disabilities wanting to see that change. And I'll stand for questions at the appropriate time. Thank you.
Very good. Thank you. Next, we have Barbara Hickard.
Oh, good afternoon.
Good afternoon.
Good afternoon. My name is Barbara Hickard. I'm with the Office of the Kansas Long-Term Care Ombudsman Program. And I want to thank you for the opportunity to provide our agency support today in support of House Bill 2122. Our agency advocates for the rights of residents in adult care homes across our state, and we work to improve their quality of care and quality of life. One of the primary ways we do this is by working to resolve complaints that are made by residents or by other people on their behalf. And in my testimony, I talk about some of those complaints that we regularly receive regarding guardians, but also other substitute decision makers. We know that guardianships are sometimes necessary, and also believe that it is a very good practice for all adults, especially older adults, to plan for their futures with advanced planning documents, such as powers of attorneys and living wills. Substitute decision-making does not replace any of that for older adults. It just adds another tool that older adults can use to continue to make decisions while they're able, but where they need some additional supports to be able to do so. It could also help to reduce the need for guardianships, though. Some of those that we see that are pursued to solve some practical problems, such as discharge planning from a hospital or from a nursing home, that could be resolved without stripping older adults of their rights. For older adults with dementia, as that dementia progresses, it could provide that person supporters with a history of practicing substitute or supportive decision-making that involves the person with that decision-making process better, and that then will better prepare them for making those decisions when that person is no longer able to participate in that process. As is true for all of us, the more of their life and their decisions older adults are able to maintain control over, the better their physical and mental health outcomes. I thank you, and I'm happy to answer any questions you have for me.
Very good. We will get back to questions in a little while. Next, Amy Campbell.
Thank you, Mr. Chairman. My name is Amy Campbell. I work for the Kansas Mental Health Coalition. We testified in support of the former bill, and we are here again to testify in support of providing this option. Supported decision-making offers options to individuals that are seeking assistance with financial or health decisions without requiring them to give up their independence and the ability to make their own life decisions. It's particularly an important tool for Kansans who may face difficulties due to living with disabilities or mental illness. I don't want to take up very much time because I think you'll hear from a number of people who have personal experience with this. Just want to let you know that our coalition does include people who have lived experience with mental illness and family members of those who have experiences with chronic mental illness, and we are very supportive of passing this option for those Kansans who could take advantage of it. Thank you, Mr. Chairman.
Thank you. Next, Colin Olenek.
Can you all hear me?
We can, yes.
Yes. I am a first. My name is Colin Ornick, and I work for the Self-Advocacy Coalition of Kansas. I am testifying in support of House Bill 2021. My experience is with my father and myself. My father set up an ABLE account for me and had to get a durable power of attorney to get it to have the ABLE account people recognize him. He doesn't want to have durable power of attorney over me, and he wants me to have all the rights I currently have. And this would provide a much lighter, less costly option for us. It costs my father, I'd say, $200 or something to get a durable power of attorney. And this wouldn't cost anything. And I would maintain all my rights and be able to make my own decisions concerning my ABLE account with his advice. It would also just help me generally with financial stuff. If I understand what's going on with a particular issue involving myself, I can make a decision that I'm comfortable with. And I'm here to answer any questions you might have.
Very good. Thank you, Colin. We will get back to questions in a little while.
All right.
We may be back to you. Next, Brad Lennenkamp.
Hello. Just a second, guys. Thank you for the opportunity to speak to the committee today. My name is Brad Lennenkamp. I have been a long part-time disability rights advocate in the state of Kansas and around the country. I literally would not be sitting here today with you if it weren't for supported decision making. I was raised to be independent, a productive citizen by parents who taught me the value of standing up for myself. They also supported me in decisions that didn't quite work out the way it was planned. The important fact is that it was my decision. An example is that years ago, I would take someone with me to the when I went to see the doctor's office for appointments. Far too often the medical staff only talked to the person that came to support me. I don't take anyone with me anymore, and people are forced to address me as the competent individual that I am. I have been employed at my current position for over 20 years as a disability rights advocate. I own my own home and an accessible van. And none of this would have been possible without supported decision making. And one of the last things I do want to add is that with supported decision making compared to guardianship, with supported decision making, it means that your rights for advocates and people that use it cannot be taken away. Where under guardianship, that would be totally different, and people's rights are taken away and decisions are taken out of their hands. So thank you for your time, and I will take questions at the appropriate time.
Very good, thank you. Next, Sean Swindler.
Hi, my name is Sean Swindler. I am a lifelong Kansan who currently resides in Olathe. I'm the parent of a 19-year-old with autism and an intellectual disability who is on the IDD waiver waiting list. I'm testifying in support of supported decision-making as an option for Kansans with disabilities. My son is 6'7" and 250 pounds. He loves animals, Disney, Pixar, and collecting action figures. He has many skills. He has always had a strong vocabulary. He recently began working part-time after school through the PREETS, Pre-Employment Transition Services Program. However, he does not do math beyond the first grade level. He decodes words well, but can't tell you the deeper meaning of what he's read, and doesn't understand basic social interactions you and I take for granted. Despite these deficits, he has the potential to someday live semi-independently, hold a job, or have a family. So my wife and I do not want to have to take guardianship of our son. We believe his best option to live a complete life and to maximize his independence is for him to be his own guardian. He'll be able to do this if he can, like many young adults, work within his circle of supports to make major life decisions and to have available guidance on most major life decisions, entering into contracts, medical issues, major purchases, things like that. These are things that all young adults rely on their family and friends to help them through, and it shouldn't be any different for a person with an intellectual disability. There are real fears as he becomes independent and moves into the community around financial matters, developing social relationships, but we believe supported decision-making would be an ideal tool to assist him as he moves out on his own. We also believe that should anything happen to us, using supported decision-making is a better fit for our son, who simply needs support for these key decisions, as opposed to full guardianship, which may interfere, despite best intentions, with his making key life choices. Our son has a strong support system with both of his parents, 3 grandparents, and other family and community connections. Given this, he'd be an ideal candidate to be empowered and supported to make his own decisions to live and grow more independent using supported decision-making. So I strongly support and hope this can be an option for my son.
Thank you. Next, we have Mike Burgess.
Thank you, Mr. Chair. I'm Mike Burgess with the Disability Rights Center of Kansas, and I think the other conferees have done a great job of explaining what this is. So I'm going to skip. You have my written remarks and just focus on a couple things. And I previously had shared, because one of the things that's a challenge is until you really look at a sample template from another state, it's hard to really know what we're talking about, and really the goal to make this whole process simple and accessible. Because you can go Google durable power of attorney and spend a couple hours reading about durable powers of attorney. And at the end of that, you probably will be more confused than you were when you started. And that's part of the reason you need to go talk to an attorney and have them assist. And, and that's a great tool. That's an important tool. Guardianship is also an important tool. But I had shared with the chairman a couple of examples, and I think that would help. And so if you would be willing to share those with the committee members, I think that will help kind of people to feel like you know what we're talking about and be able to see it. So the other big question I think that I just want to hit home is, why we need this. Because you've heard a couple of folks, both Colin and Brad, they are currently using supported decision-making in their lives. And it exists today. It's as previous conferees have said, we have some of the foremost experts in the world on supported decision-making right here in Kansas. It pains me as a good K-Stater, but KU does a great job there, so I'm going to throw some props their way for the work that they do on this. And we've even been able to secure some grants, some competitive grants through the federal agencies to help develop and promote and plan on how we can further implement supported decision-making here in Kansas. In fact, we were one of only 3 states to receive those. So that's, I think speaks to the previous work that's happened on the ground to set this up. So we need that. Why do we need the act? Well, it creates additional recognition for the agreements. It sets forth the baseline templates or requirements for an act, what an agreement needs to have, and also would task the Judicial Council with developing, a form, a sample form, and it would likely look something similar to what the ones the chairman's going to share with you, but wouldn't have to be just like those, obviously. And so I think that way we can have a Kansas solution to this and help make, and again, if anyone has worked on a car or a project in your house, the value of having the right tool to do the job. And again, there are a number of great tools out there today for specific jobs. This is one that's missing and will help a lot of families with that. The other piece that I want to add, it also adds safeguards. So if a supporter, like anything, you're going to have bad actors. You can't, as much as we like to set up safeguards, that is going to, someone will find a way to abuse this. Well, this creates enhanced penalties. It sets it as a trusted relationship similar to a power of attorney, a guardian, a conservator, where it triggers enhanced penalties and makes it more likely that a crime would be prosecuted if it is committed against an individual. And so with that, Mr. Chair, I'd be happy to stand for questions at the appropriate time, and hope you shed a little bit more light on why we need this.
Very good. Thank you. Committee, I'm going to go through the list I have as written because I know some of them are appearing online, but I don't think they want to testify, but I'm going to go through the list just to make sure no one wants to testify. I have the Alzheimer's Association. Lindsey Ford. Lindsey, are you still with us? You're online. Let's see.
Yes, I'm still here. We offered just written testimony, but I'd be happy to stand for any questions.
Awesome. Thank you. Then we have the CanCare Advocate Network, Kansas AARP, Jawanda Mast, a parent advocate, the Kansas Advocates for Better Care, Nikki Hyman, a parent advocate, and then Jeff Schroeder. Is there anyone else, either in person or online, that's a proponent? Okay, not seeing any. Now let's do questions. Committee, what questions do we have? Representative Humphreys.
Thank you, Mr. Chairman. I'm trying to recall some of the testimony before, but so one of my questions was then, and I think now, was how many states already do this? I'm thinking Missouri has it, is that right? Or what did we hear before? Other states that have it, and then that also plays into the question about that the 65% in Kansas have guardianships, but only 35% average. Is that specifically because of this, or is there something else playing with that 65-35% thing?
Well, Okay, first question
Yeah.
on Missouri.
Uh-huh.
Missouri went through and actually redid all of their guardianship laws. They went through the entire guardianship law and added in a bunch of supported decision-making pieces to it. And so they did a very complex renewal of all that, or review of all that, and update of all that, I think, in the last year or two. And they've got a wings group, and they've got a few groups that are working on that. As far as the percentage of people that have guardianships in Kansas, we have a real hard time getting at that number because we couldn't really find a way to find that. And so the only thing that we could find was there's a survey that's done every year by the National Core Indicators, and they're the ones that came up with that there's 65% of the guardianships in Kansas, and 35 is the national average, and there's some states that only have 5%. And the other thing that I found in that was we only have about 3% of our guardianships are actually limited guardianships, which really concerned me because I can't imagine that it's all or nothing, but that seems to be the way it's being treated right now. And so that's one of the reasons why we really think supported decision-making as an option will give people more options to choose from and won't be quite as,
May I follow up? So, but do you think it's because of, I mean, so remind me, do other states, so besides Missouri, they do have some supported decision-making, but do other states have it? And
right now, the last information I have, there's about 17 states that are working on some kind of supported decision-making. The first state to pass supported decision-making was Texas a few years ago. Alaska did in the last year or 2 years ago. And there's been several other states as well.
okay, and that might play into the disparity of those percentages, or do you have any idea? I mean,
I really think part of that disparity comes from our education system right now is encouraging, or not necessarily encouraging families, but one of the things that happens is they have to remind families about guardianship whenever their son or daughter is turning 18. And instead of just reminding them about guardianship, it's kind of turned into, we don't know a lot about this, but we're supposed to say something about it. And so then families think, oh, maybe I'm supposed to get guardianship. And so I really think we have a lot of unnecessary guardianships because people really don't talk about the options. And like in the District of Columbia, they actually started teaching the school districts about supported decision-making, and they've had a 10% reduction in the number of guardianships in the last year. And that.
okay. And to do the, if I recall, with the Judicial Council having a form, it needs to be notarized, so there's no expense of an attorney and so on.
Yeah. If you want to go to an attorney and go through a process with that, you can. If you don't want to, you don't have to. And the thing that we're really trying to get with this piece of legislation is anything that meets the standard works. And if you want the form, we can use the form, but you don't have to actually use the form. And so you have options that way. And again, we're just looking at how do we give the families the most options.
Okay, thank you. Thank you, Mr. Chairman.
Other questions, committee? Representative Carmichael?
Thank you, Mr. Chair. I think I learned something today. I think I've been mispronouncing Steve's name for 6 years, 7 years now. I apologize to you, sir. I understand, I think that this is a good idea. But here's where my concern lies, and I hope that one of our conferees can relieve that concern. I hear examples that Missouri adopted a supported power of attorney, or whatever we call this, and I'm sorry, supported decision-making. But they did that as part of an overall review of the probate code. And when I see a particular idea pop up without testimony and support from folks who do regularly practice in probate law, it causes me to wonder what, if anything, are we overlooking here? Or what, if any, unintended consequences might arise were we to enact this bill? And I'm sorry, I have not had a chance to read all the testimony here. There may be an absolute expert in the probate law sitting right here. And so I'm hoping that someone of the conferees can satisfy me that we have properly vetted this to make sure that we're not making an unintended or making a decision here that might have unintended consequences. With some of the conferees help me with that, and I don't discriminate against whether you have a JD or not, but it is a form of qualification that's relevant to our inquiry.
And thank you for the question.
I thought you might be there, Mike.
So one of the folks, several of the folks that we've consulted with are all attorneys and do practice in this area. And one of the attorneys within our shop is a standing member of the guardianship committee on the Kansas Judicial Council. And so he is definitely one of the ones that we have been consulting with on this and is definitely supportive of this concept. And several of the attorneys practice both in Kansas and Missouri. We had one, is he from New York? Trying to think he actually used it to help an individual. He represented Jenny Hatch, who was an individual who used supported decision-making as to help assist in getting out of a guardianship. She was in an unnecessary guardianship, and that was how she proved to the court she had competence to be able to, or had capacity to be able to operate. And so she successfully has used supported decision-making. So it is a great question, and definitely there are a number of folks who are experts in the probate law who are supportive of this. So thank you.
Okay, but the problem is I don't see their names on the testimony. They're not here to ask questions of, and I believe your word. I understand that. What would be, though, the disadvantage other than a year's delay to sending this to your colleague who is on the Judicial Council and making sure that we've taken a look to make sure we're not, because I'm not a probate lawyer, I wouldn't recognize a flaw in this bill if one exists. Is there a reason that these ideas shouldn't go to Judicial Council, or for that matter, even the Probate Committee of the Bar Association, to make sure that what we're doing here is the right thing to do?
So I can assure you, those were some of the first calls that we made, and so we sought feedback from both of those organizations as we've done this. So.
But of course, I don't see anybody from the Bar Association here, and I don't see their testimony. That's a rhetorical question. Thank you, Mr. Chairman.
Any other questions, committee? Don't see any online, and I'm not seeing any in person. So let's move down the list. I don't have any opponents listed. Do we have any opponents? Neutral, I have one written neutral from the KU Center on Developmental Disabilities. Is there anyone else as a neutral? Not seeing any additional ones either, so we will close the hearing on House Bill 2122. Committee, that's all we have today. Thanks for your attention and participation. Have a good weekend, unless you want to hang around and join us in conference committee, because that might happen over the weekend.
Can I be excused? Can I be excused? Can I go?
Not all of you can be excused.
Sorry.
Thank you all. We'll see you on Monday. We've got a busy, packed full week next week that will continue to get fuller as I send out a revised agenda. So thank you.